Dryden and others versus Johnson, Matthey Plc.
I will ask Lady Black to summarise the judgment of the court.
The appellants all worked in factories making catalytic converters. In the course of their work, they came into contact with platinum salts, which are used in the production process. That happened because of the failure of their employer, Johnson Matthey, to ensure that the factories were properly cleaned. As a result of being exposed to platinum salts, the appellants developed platinum salt sensitisation. Platinum salt sensitisation does not itself give rise to any symptoms. However, if someone who has been sensitised then has further contact with platinum salts, he or she is likely to develop an allergy. At this stage, the person will have symptoms such as a runny nose and eyes, asthma, and skin rashes. Because of the risk of employees developing an allergy, Johnson Matthey ensured that they were regularly tested for sensitisation by means of a skin prick test. Anyone who tested positive was no longer able to work in areas of the factories where he or she might be exposed to platinum salts. So it was with the appellants in this case. Once they tested positive, they were unable to continue with the jobs that they had been doing up to that time, because those jobs might involve further exposure to platinum salts. This caused them a loss of earnings. They therefore brought claims for damages for personal injuries caused by Johnson Matthey's negligence and or breach of statutory duty. At first instance and in the Court of Appeal, they lost on the basis that platinum salt sensitisation did not constitute actionable personal injury, and they'd simply suffered economic loss, which they were not entitled to recover from their employer. The UK Supreme Court unanimously allows the appeal, finding that the appellants have suffered actionable personal injury. In reaching this decision, this court examines what is meant by personal injury in the context of a claim for damages such as these appellants have brought. Often, personal injury is easy to identify because it involves obvious pain, suffering, and loss of amenity. But it is well established that a physical condition which is hidden and symptomless can also be actionable personal injury. Actionable personal injury can be found described in the existing case law as a physical change which makes the claimant appreciably worse off in respect of his health or capability. It's also been said to include an injury sustained to a person's physical capacity of enjoying life, and also an impairment. The physiological changes that have occurred in these appellants' bodies are undoubtedly harmful. Their bodily capacity for work has been impaired by their sensitisation, and they are therefore significantly worse off than they were before they became sensitised to platinum salts through their employer's negligence and or breach of statutory duty in failing to look after their working environment properly. In the circumstances, their sensitisation is properly classed as actionable personal injury.
The court will adjourn for a few moments and we'll resume with further judgments later.